Fabulous. All right. So the goal today is we're going to cover the new representation agreement. They have eliminated the old one and replaced it with a new one. And then we'll also, if we have time, talk about some of the other new forms they've added. And we can also talk about some of the changes that were made to other forms. I'll also show you where to get that information so you can track it down. There's no way we'll get through all of it today. There was a lot of forms. There were, hold on, let me tell you. I want to say there were like 9 forms added to the transaction. Let's see, 1, 2, 3, 4, 5. There were 9 new forms added to the CAR forms library. I'm not exactly sure how, as a brokerage, we're going to incorporate some of those in, if we are going to or not. But we'll go over all those new forms. And then there was probably double that in forms that received edits or changes. Some of them were pretty simple. So there were, and this all happened, just so you guys know, it all happened at the end of December. They like to screw up the end of our year by by changing all the forms. So as you're trying to close out the end of the year, everything changes. So they updated 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 different forms they updated. They added the 9 forms, and then they eliminated a couple forms as well. So just a heads up on that. The ones that they eliminated, they're not going to affect you that much. One of them was a trust fund form, not a big deal because we don't deal a whole lot with trust funds. The second one they eliminated was the buyer representation. They eliminated the buyer representation exclusive, the buyer representation agreement non-exclusive, the buyer representation agreement non-exclusive, not for compensation, and they replaced them all with the BRBC. So that's our intention today, is kind of cover that form so that we can understand it, kind of have a better way of describing it to our people. And I feel like I may have, hold on, the sharing stopped. So hold on, let me reshare. Maybe. Oh, I am screen sharing, so it should be there. All right. Can somebody put in the comment section if you can see my screen that's pulled up with the CAR forms library? Carly's shaking her head yes. So
yes, we can see
thank you, Carly. Most everybody's pictures. I can see you though, so I appreciate that. Thank you, Rebecca, as well. All right. So the BRBC, in case everybody wonders where I'm at, I am in the new forms editor. In case you haven't been part of the trainings over the last couple of weeks, I do recommend using the new forms editor. It's super handy and nice. It allows you to edit multiple forms at the same time. Instead of opening one, closing out of it, opening the next one, you can just keep going through those forms that are added to your transaction. So with the BRBC, or the Buyer Representation and Broker Compensation Agreement, number one, I recommend using this with all of your buyers. Please use it with all of your buyers. I cannot stress that enough. I don't know why in the state of California we don't make this regular practice to use this form. Most other states actually require you to sign some sort of representation agreement before you can even go show properties. But in California, it's become an optional thing. And then the number one complaint that I get from people is, my buyer, they ghosted me and they started using somebody else. And what can I do? And I'm like, well, do you have some sort of buyer representation agreement signed? No. Well, there's nothing you can do. Adios, goodbye. They've gone. They've moved on. That being said, I never hesitate to cancel one, but there's some ramifications that go along with that, which we'll talk about. Coupled with this buyer representation and broker compensation agreement, you're going to see that there is a agency disclosure. Same thing that you're going to see with a listing agreement or a buyer's rep agreement, right? I'm not going to go over this in detail. This form is not new. It was not changed. The best way to describe this is the way that you can be represented in the course of a transaction. You can either be represented as a seller's agent, where you are listing your property for sale and somebody is representing you and selling that property. You can be represented as a buyer's agent, where you're looking to purchase a property and you're being represented in the purchase of that transaction. Or you might be represented by both. Somebody is selling a property and the same person that represents that person is also helping the buyer purchase the property. And then it goes through the seller and buyer responsibilities. Here's my normal caveat. I'm going to share this with everybody just so you hear me on record saying it. I highly don't recommend that you represent both the buyer and the seller in a transaction. Okay, there is so much gray area. If you're going to have any problems arise, it's going to be from that. There's a few little like random transactions that I would say, hey, it's totally fine to do both. You know, like if you're helping a tenant purchase the property from a landlord, if you're helping a purchase between family members, like random stuff like that, yeah, go ahead and do it. But when you're representing a seller in a transaction and then you've got a random buyer looking to purchase that property, it's really hard to keep that confidentiality and all those gray areas separate. So I just recommend referring it to another agent in the office and collecting a referral fee for that buyer if you have a listing and you're also got the buyer for the property. There's my little caveat. As always, if you have questions as I go through this, feel free to interrupt me, raise your hand, let me know you have a question. Trying to watch your little pictures. And I also have the chat box up, so I'm trying to keep an eye on that as well. I do have two screens, so if it looks like I'm not looking at you directly, that's why I'm bouncing back and forth between the two screens, so I apologize. Second page of that agency disclosure is just all the legal jargon that goes along with it. Along with that, you have the Fair Housing Discrimination Advisory. These all should go out with your representation agreement. Just stating that as real estate agents, we cannot discriminate by any of the protected classes, which is basically like for any reason, we cannot discriminate. They're all listed here. It's a 2-page document, gives you some examples. Okay, but that's the summary of that form that I would explain to a potential buyer. The possible representation of more than one buyer or seller disclosure and consent is also included. Just stating that, hey, I'm working with multiple buyers at the same time. And at any time, I'm not going to steer one of my other buyers away because you've decided to write an offer on a property. I'm not going to tell them they can't write an offer on a property. However, I'm also not going to disclose the details of your offer to one of my other buyers. Okay, multiple buyers. The other thing to let somebody know is that offers are not necessarily confidential. So again, this isn't necessarily a change, but just something to be aware of as you're going through these forms with a potential buyer, that you should be advised as a buyer that the seller may not keep your offer confidential. They may share the terms, the purchase price, whatever, with other potential buyers or agents looking to make offers on that property. The only way to avoid that is by signing a written confidentiality agreement. There is one in the Carforms library. My experience with that confidentiality agreement is it's really hard to get somebody to sign one of those before you submit an offer to them. When the market's super hot and there's 20 offers coming in on a property, they don't care about your offer. As the market's slowed just a hair, you might be able to get one signed now. However, that's kind of been my experience, is people would rather forego your offer than sign the confidentiality agreement. So just kind of be aware of that. The next form is that wire fraud and electronic funds transfer advisory, which just states, hey, buyer, if you're asked to wire any funds, please confirm with the person that should be receiving that wire that the instructions you received are accurate before sending any wires. Okay, the next form is the actual document. So this is the new form. As we've noted before here at the top of the form, it does have a date, so you know that you have the most recent copy of any form for any changes that were made. So this is the Buyer Representation and Broker Compensation Agreement. Representation period and right to present. So here's where you're going to put in the buyer's names on that first line. And it's going to be buyer 1 and buyer 2, whatever their names are. Grants, Realty One Group Fox, who's the broker. Beginning on, in order for this to be valid, there has to be a beginning date and an ending date. Okay, so we're going to begin it. If we double click, it just puts in today's date. Super handy. So if we're drawing this up and the buyer's there in the office, makes it super easy. Just double click on that date line. It'll fill in today's date. And then we need to say, how many days is this going to be good for? Is it good for 365 days? Is it good for 120 days? Is it good for 90 days? You get to make that determination. There's no wrong or right answer to that, but you can decide how long this representation agreement is going to be in place. Part of it's going to depend on the motivation of your buyer and their ready, willing, and ableness to move forward with the purchase and what that time frame looks like. It's going to, right? So it's going to be 1/31/2023 and ending 120 days later at 11:59 p.m. Okay, or upon completion of a resulting transaction, whichever occurs first, the representation period. So this is either going to end at the end of the time frame if they don't buy a house, or if they buy a house at the end of the transaction when it closes, this representation agreement is concluded, it's finished. Okay. This is a non-exclusive contract. So I'll show you how to change that as we move through this. But the non-exclusive right, unless paragraph 4B2 is checked, to represent the buyer in acquiring real property or a manufactured home. What that means, non-exclusive, is that you're only due a commission if you helped them to locate and enter into contract on that property. Non-exclusive. Okay, if their friend decided to sell their house next door and they decided that they were going to go that route and buy that house, with a non-exclusive agreement, you are not due any compensation for that transaction if they decide just to do it personally and not involve you. No pre-existing, anybody have any questions about that first section before I move on? All right. No pre-existing buyer representation and compensation agreements. Buyer acknowledges that the buyer has not entered into a representation agreement with another broker and has no obligation to pay compensation to any other broker arising out of the acquisition of the property identified in paragraph 3, except, and you're going to identify brokers and properties. So if this buyer was in a contract previously, a representation agreement previously, and they've already seen some properties with another broker, they received a list of properties from that broker, then we would put that broker and those properties on that line. If they decide to write an offer on that property, you're not going to get compensated for it. The other broker is. So your probably best bet is to let the other broker write the offers on those properties if they decide that's the direction they want to go. But you would need to make sure that you have a conversation with your buyer and make sure that they have not entered into any other agreements with other agents or brokers. Okay, that's number 2. Number 3 is the property to be acquired. Okay, location, cities of, counties of, price range, other, the following properties only, the properties identified on an attached list. So you have several options there. Location could be something specific, could be in and around in the greater, and then counties of Sacramento or whatever, Sacramento,
Amy,
the greater Sacramento area. Yes.
so with the ones of us that do the Zillow, can we just do like a blanket one and do like Sacramento, Solano, Contra Costa counties? Is that, or do you want one for each county?
No, you don't have to do a separate one for each county, just a separate one for each buyer. So wherever that buyer is looking, I mean, if you've got a buyer that's looking, in the Sacramento County area and they have no interest in Contra Costa, then you don't necessarily need to include that in your representation agreement, but you always could. By posting the counties here too that you cover, if you were to always plug in all the counties that you cover, it makes the buyer aware that, hey, not only can I look in Solano County, but they also cover Napa and Sonoma counties too. So it doesn't hurt, but you just want to define those areas for which you're responsible and that they're interested in buying.
Thank you,
Okay.
ma'am.
Yep.
So Amy,
Yep.
I'm sorry. So that part is kind of different, right? So we were to write in the greater Sacramento area on the top, and then we're going to also call out the counties, or
You don't have to,
Either
you
or.
can just leave it blank and just put in counties or cities. You can put something up there. You don't have to fill in both.
oh, okay. Okay, because I wasn't sure what to do, so I wrote in the location. I think I just wrote all of that what you wrote in the location.
You could do that as well.
I was like,
For
am I supposed to
location-
fill each individual thing?
For
Amy, I have a
location, could we
question right
do-
quick.
Whoops.
Sorry, go
Say
ahead.
that
Sorry, I just wanted to ask you something right quick.
Yeah.
So I've always just put TBD there, to be determined. So I'm not limiting myself to any specific area.
No. You always want to be specific in the areas that you cover, not just to be determined. If you wanted to put, I mean, the only way that to be determined would work would be like in the following specified properties only. You could put location to be determined and then in the cities and counties of, so that would work there to put, like the specific locations to be determined. but it's going to be located in these specific counties. And like I said, you could outline all the counties that you're willing to go to, but you do want to be specific in that and not just be super vague, because then if they decide, technically, if they decided to purchase down in San Diego County, you would be due that commission, which isn't really fair or accurate if their plans change. So just put it in the counties in which you service.
Okay, thanks.
Yep.
Would we ever, for location, can we get away with Northern California? Or is that too vague?
You could probably get
We're
away with
like
Northern
California, California.
Yeah,
Northern California.
I would probably be more specific than California, but you
No, I
could
said
probably get away
Northern
with Northern
California.
California. Although again, I would probably choose to be more specific than that, because you want it to make sure that if it ever you had to go to mediation or arbitration over this, that you want it to be as specific as possible so that it's going to hold up.
Thank you, ma'am.
Yep. Price range, I would put in a price range here and I'd go higher. So if your buyers, are pre-approved for 800,000, I'd probably put in like 950,000. So I'd probably just put a little buffer zone there. And I'd probably go like 0 to 950,000 or whatever that is. So again, we're looking to be specific to protect ourselves in the case that they decide to go someplace else. So we want to leave that buffer zone there, but we do want to fill something in. You don't necessarily have to, just the more complete a form is, then the better it looks when you're in front of a panel of people, if you ever had to defend it. And then there's an other line, because as our car forms always like to do, they give us an other line there in that location. So that's one option. If it was a specific property, they were coming to you for a specific property, you could check the box here for B instead of A. So the default is A. If we check B, and then you could plug in the specific properties there for which you were going to represent them in, or you could attach a list as well. So it would be either A or B or C. You wouldn't want to check all the boxes. You just want to select one of those options. Okay. Compensation to broker. The amount of, it says, notice the amount of rate of real estate commission is not fixed by law. They're set by each broker individually and may be negotiable between buyer and broker. The real estate commission includes all compensation and fees to broker. Buyer agrees to pay broker as follows. One applies unless 2 or 3 is checked. Do not check both. So one applies would be a percent, right? So if we're like, hey, we want no less than 2.5% to represent you, and blank, maybe you want like an additional like fee to cover your transaction fee, right? So you could go like, hey, I want 2.5% plus $900. That would be a way to do that. Maybe you're like, man, I know the average is 2.5%, but I always want 3%. So you could put that in there. There's no wrong or right answer to this. It's whatever you want to work out between you and your buyers. So that's option 1, is you can plug in the percent, and there's always a place for the percent and. Okay, so percent of the acquisition price and you don't have to fill in the and. You can just fill in the percentage if you want to. The average commission in the MLS is 2.5%. If we go with box number 2, it could be a flat fee. So maybe we're representing the buyer in the purchase of a family-owned property, and we decided that, hey, we're just going to charge a flat rate because it's pretty easy. We're really just pushing paper. So maybe we go and instead of that percentage here, maybe we're going to say, hey, we'll do it for $7,500, right? So you could put in a flat rate there on number 2, or it could be a graduating percentage, right? Where if different price ranges, maybe if they purchase a property under 300,000, then you're due 4% commission. And if they purchase one 300 to 500, then you're due 3% commission. If they purchase one over 5%, then you're due 2.5%, or whatever that is. You could do like a graduated compensation schedule attached, which is number 3. So those are your 3 options. They're either a percent, a flat rate, or you could do a graduated or some sort of compensation scale. Okay, any questions about that on section 4?
To be clear, the sellers, so the listing broker determines the buyer's agent commission. So for instance, if I had a buyer's agreement like this and I said that I wanted 3%, but the listing broker of the home that they ended up purchasing only allowed 2.5%, that would mean the buyers would then owe me an additional 0.5%, correct?
That is accurate, or you would want to revise your agreement to be the 2.5. But yes, if you put 3% there and the seller, which we'll cover here in a minute, the seller is only offering 2.5%, then the seller would pay 2.5% and the buyer would still be responsible for the additional 0.5%.
Okay, I just wanted to verify.
Yep. Okay, the broker right to compensation. The broker shall be entitled to compensation specified in paragraph 4A from buyer if during the representation period or any extension thereof, the buyer enters into an agreement to purchase, lease, or otherwise acquire any property described in paragraph 3, and the seller therefore completes the transaction or is prevented from doing so by default of the buyer as follows. So see, even if the buyer defaults on the purchase, you may still be due a commission. The broker involvement, non-exclusive representation. Compensation is payable only if there was broker involvement with the property. Broker involvement means any of the following. Buyer physically entered and was shown the property by broker. Broker showed the property to buyer virtually. Broker submitted a seller a signed written offer from buyer to acquire, lease, or exchange or obtain an option on the property, or the property was introduced to the buyer by broker or one for which broker acted on buyer's behalf. However, merely sending buyer a list of properties shall not be deemed broker involvement without documented action on the part of the broker analyzing the property for the buyer specifically, or assisting buyer in the potential acquisition of the property, or communicating with the seller on seller's agent regarding buyer's potential acquisition of the property. So just sending them a list of everything on the MLS does not cover you there. Okay, that's the non-exclusive. So you either have to have like show them the property either physically or virtually. You had to write an offer, right? You have to be physically involved in the process of acquiring that property. So that would be the non-exclusive. I highly recommend you check the box for 2B2, which is the buyer acquisition is an exclusive representation. This agreement shall be exclusive and irrevocable. Buyer will devote time and resources to assist, or broker will devote time and resources to assist buyer in finding and acquiring the property in the expectation of being paid for broker services. The broker is entitled to compensation if buyer acquires a property during the representation period with or without broker involvement, even if another broker is also entitled to be paid for the representing buyer. Okay. So if they've entered into another agreement, if they had a previous agreement in place and we check this box so that it's exclusive, even if they're due to pay the other broker as well, you would still be due. Okay, you can work that out with your buyer on how you decide that actually plays out in reality, but this is a exclusive representation. Same idea as we always sign the exclusive listing agreement, which means that, hey, even if we brought the buyer or not brought the buyer, even if your neighbor decided to buy the house, we still get compensated. Same idea here with your buyers. The buyer includes any person or entity other than broker related to the buyer or who in any manner acts on buyer's behalf to acquire the property described in paragraph 3. So I have an agreement with the buyers and they decide to have their son purchase the property, right? Like a straw buyer. You're still due that compensation because they're buying it on behalf of the original people. Okay, so I highly recommend you check that box for 2 to make it an exclusive representation agreement. Cancellation of buyer representation agreement. Either buyer or broker may cancel this agreement in writing by giving notice to the other. This agreement shall be terminated if paragraph 4B1 applies upon receipt of the notice or blank days after receipt. So you could be like, hey, or it expires, 10 days after receipt, or maybe it's 30 days after receipt, whatever you want to put there. You could leave it blank as well, which would just be on receipt of notice. So that's if you don't check box 2. Okay, so if you're going with the default of 1, that it's a non-exclusive, they can cancel it at any time. Doesn't matter. As soon as you receive the notice, it would be considered null and void. If paragraph 4B2 applies to the exclusive representation, then it would be 30 days after receipt of the notice. Broker shall nonetheless be entitled to compensation if during the representation period or any time specified in paragraph 4E, which we haven't gotten to yet, buyer acquires property for which there was broker involvement. CAR form NBIP. This is a new form as well. Paragraph 4B1. Provided broker delivers to buyer a written list of those properties for which there was broker involvement. The written list of broker involvement properties shall be delivered to buyer within 5 calendar days after the effective date of the cancellation. Before, during, or after the 5-day period, buyers advised to notify any other broker of broker's rights under this paragraph. So this just states that, hey, the buyer can cancel this contract. It's a 30-day notice. So if I say, hey, I'm done working with you, here's my notice. They have 30 days that they can't go work with another broker, or you could be due the compensation. And you have 5 days during the expiration of that cancellation notice to provide them with a list of all properties shown. So is it really important to track all the properties that you've done any sort of work on for these buyers? Everybody say yes. Okay, I use carts for this reason inside of Barry's. I create a cart. I call it like Heather Garcia and the date that I showed properties, and I put all the properties we saw into that cart for that day. So it makes it really easy for me to go right back into my carts and look at those properties. Or if they've asked me to look up information for those properties, I'm going to create a cart for that as well, so that I have a cart of properties that maybe they decided not to see during the term of our agreement, but they asked me to do work on, because that also qualifies for compensation. Okay. If checked, only paragraph 4B2 applies. Neither party shall have the right to cancel this agreement prior to the expiration, except by mutual agreement. So I would probably check, if this were me and I was filling this out for my buyer, I would check box 4B2 for the exclusive representation. And then I'm also going to check 4C2, stating that neither party has the agreement to cancel without mutual agreement. It's really the same thing. There's no set rules there, but it just gives the buyer that out. Would Zillow activities count? Rebecca, can you unmute yourself and elaborate on what that question is? All right, we'll come back to that one. Right. I actually kind of like the default one here a little bit better than 2, but 2 is a little cleaner and a little less scary for a buyer. Okay, it's still going to fall into this category down here under E anyways. Accounting for payments to brokers by others. If anyone other than a buyer compensates broker for services covered by this agreement, that amount should be credited towards the buyer's obligation to pay compensation. So that's what Jennifer was mentioning earlier, is if we say, hey, it's a 3% commission and we get 2.5% from the seller, this is just saying that that reduces the buyer's obligation. So if we had 2.5 up there and the seller's paying 2.5, the buyer wouldn't be obligated to pay anything else. Anything we receive from another party towards this compensation for this transaction counts towards their obligation. Okay. D2 is if third-party payments received exceed buyer's obligation, the excess amount shall be paid to broker or credited to the buyer or other. So this is, hey, if we had 2.5% up there and we came across a listing they wanted to write an offer on that said 3%, what happens to that extra 0.5%? The default is it gets paid to you, the broker, the agent, right? If we check this box, then it goes to the buyer. And if we check the other box, we could say, hey, it's split between the buyer and the broker, the buyer's portion to be credited towards their closing costs, or whatever you wanted to put there, right? So there's no wrong or right answer there, but it defaults to it gets paid to you. So if it's 2.5 on the agreement, MLS says 3, you get that extra 0.5%. Authorization to include commission in offer. The buyer authorizes is the default. The broker to include a term in the buyer's offer obligating seller to pay brokers directly through escrow for any compensation that the buyer owes broker. Okay. The other box is that it does not. So it'd be that the buyer does not authorize the broker to include term in buyer's offer obligating seller to pay buyer directly or through escrow for any compensation that the buyer owes the broker. Okay, there's a new part in the purchase agreement. It was edited that includes this now, and you would include a separate form in there as well. So you would put that in there, and then there's a form that goes along with that. Additional broker right to compensation. The broker shall be entitled to compensation provided for, Broker shall be entitled to the compensation provided for in Paragraph 4A, if within blank calendar days after expiration of the representation period or any extension thereof, if there is a cancellation after the effective date of the cancellation in paragraph 4C, buyer enters into an agreement to acquire a property for which there was broker involvement provided prior to expiration of this agreement or any extension thereof, or if there was a cancellation within the time specified in paragraph 4C, broker delivers buyer a written notice of those properties to which there was broker involvement, form NBIP. So we come up here back to 4C, right? The cancellation. So here we want to put calendar days, right? After the expiration. I like, 90 or 120 days, whatever, something like that. It could be 30, 60, 90, 120. But if it's, I'm due the compensation if within 120 calendar days after expiration of the representation period, any extension thereof, or if there is a cancellation after the effective date of the cancellation in paragraph 4C, buyer enters into the agreement to acquire the property for which it is involved, right? We need to provide them with a list of those properties though. Okay. So that's the additional right to compensation. That covers you from a buyer being able to cancel the representation agreement, turn back around and make an offer directly with that seller or with another agent on a property that you showed them. Any questions about D or E?
So Amy, just to confirm on,
Yep.
just so I don't feel, I think I'm right. On D3, that basically just is saying that they're allowing the seller to pay my commission through escrow, basically, right?
It's allowing you to negotiate the commission as part of the transaction in the new RPA, in the edited RPA. So there's a new place in the purchase agreement where you can elect to state that the seller is going to pay X amount of commission.
Mm-hmm.
And so it gives you the ability to be able to negotiate that as part of the offer here.
Oh, okay.
So that it gets paid directly through escrow.
Oh, okay.
Okay. The delivery of those shown properties need to use that. Yes. So in order to be appropriate and make sure it holds up, you would need to provide that NBIP form for the compensation. The NBIP. Okay, so we just need to make sure to provide that on when there's a cancellation. So anytime you get a cancellation of a buyer representation agreement, you want to put that list of properties together and get it over to the buyer. Disclosure of anticipated payments to broker by others. Broker, prior to writing an offer on a property, or if checked prior to showing a property, right? So it defaults prior to writing an offer, will disclose to the buyer the amounts of compensation broker expects to receive from a third party on that property by providing buyer with either a copy of the MLS listing showing the cooperating compensation offered to buyer, or a separate document such as an anticipated broker compensation disclosure CAR form ABCD. Okay, so there's a new form. It's called ABCD. It's the anticipated broker compensation document. We'll go over that as part of the new forms as well. Or just by giving them a copy of the listing agreement, so it used to be on our client reports on the MLS. If you printed those up, it didn't show the compensation on there. But now, towards the latter half of last year, they passed a law that required that to be presented to any potential buyers. And now you'll see it like on Zillow and Realtor and any of the places really that you can see the properties. It'll tell you what the anticipated commission is or what the commission being offered as a co-op agent. So you can print up just that like client 1-page report when you get ready to write the offer, include that as part of your offer, and this covers you under this agreement. Or you can use the ABCD form. Okay. Broker independently or through escrow will disclose the final compensation broker receives from anyone other than buyer. And the buyer is responsible for payment of compensation if the third party does not pay as anticipated. Okay, keep in mind, this sounds a little scary, but I always reassure my buyers that, hey, in the case that the the compensation from the seller does not cover it for any reason or something happens, I will always be upfront with you and we'll have a conversation surrounding that. Okay, and that conversation is, are they going to pay the difference? Or is it, are you going to adjust that? Keep in mind that if you're going to adjust it based on a transaction, we need to do a modification of terms for the buyer representation and broker compensation agreement to adjust that commission. Or you could put out a specific, well, no, just do it that way. What was the printout? Oh, you could just do any of the printouts, Heather, from the MLS, but I recommend like the client one-page report is what it's called in the Barry's reports. It does a one-page summary of the property with all the features and the description and all the stuff. Also shows the compensation on there. It's just a nice, pretty way, and also gives them a copy of, what they're buying. Okay. Timing of compensation. Compensation is payable upon completion of any resulting transaction and if escrow is used through escrow. Broker shall be entitled to compensation whether any escrow resulting from an agreement for property specified in paragraph 3 closes during or after the expiration of the representation period. So same as the listing agreement. If this expires, but you're already in contract on a property, you're still due that commission when it closes, even if it's after the expiration date. Same thing with a listing agreement. If you enter into contract with that listing prior to the listing agreement expiring, as long as you close that transaction that was in contract, it still upholds under that listing agreement. Same idea here. If acquisition is prevented by default of the buyer upon buyer's default. Now, keep in mind, this is not the buyer canceled based on one of their contingency periods. This is by default, right? So they canceled outside of their ability to cancel the contract. You would be due a commission. If acquisition is prevented by a party to the transaction other than the buyer, when the buyer collects damages to that suit, settlement, or otherwise, compensation shall equal 1/2 of the damages recovered, not to exceed the compensation provided for in paragraph 4A after first deducting the unreimbursed payments, credits, and expenses of collection and suit, if any. Okay, so if the seller prevents the file from closing, the buyers sue them for performance or damages, then you're entitled to 1/2 of whatever they get, minus the fees. Okay, there is your information there. On the timing. Payment through escrow. Buyer hereby irrevocably assigns the broker the compensation provided for in this agreement from buyer's funds in escrow. Buyer agrees to submit to escrow any funds needed to compensate buyer under the broker under this agreement. Broker may submit this agreement as instructions to compensate broker to any escrow regarding property involving buyer and a seller or other transfer. Okay. So you can use this agreement to submit to title and escrow. So if you find out their contract on another property using a different agent, you can submit this showing that you're due the compensation for that transaction. They're giving you permission to do that by signing this. Okay. It also works for yours. So if there's no compensation being offered or 1%, submitting a copy of this would provide proof to both title and escrow and to the lender that the buyer is responsible for the remaining commission. Pre-existing buyer representation and compensation agreements. If buyer acquires property during the time buyer is obligated to compensate another broker identified in paragraph 2, broker is neither entitled to compensation under this agreement nor obligated to represent buyer in such transaction. Okay, so if you're going to write an offer on a property that you've already been disclosed is not due to be paid to you, don't write the offer, give it to the other agent. Or if the buyer's unwilling to work with the other agent, then it's time to have a conversation with that other agent about how they want to move forward with it. Because you don't want to work for free. Agency relationships. Disclosure. Buyer acknowledges a receipt of the disclosure regarding real estate agency relationships, CAR Form AD, prior to entering into this agreement. That was attached at the beginning of this agreement. Possible dual agency with seller. Broker will represent buyer in any resulting transaction. Broker may act as an agent for both the buyer and the seller. Broker in writing shall confirm the agency relationship with only buyer or both buyer and seller prior to concurrent Prior to or concurrent with buyer's execution of a contract to acquire a property, buyer acknowledges receipt of a possible representation of more than one buyer or seller, disclosure and consent, right? Remember, our relationship is with the broker, not with the individual agent. So if we're submitting an offer on a property that's represented by Realty One Group, even if it's a different agent, maybe Jennifer is the one representing the seller, I am representing the buyer, it's still considered dual agency. I'm totally okay with that. There's that degree of separation there. My statement earlier today in the training was that representing both the buyer and the seller as an individual agent becomes very hard and difficult to maneuver. But anyways, possible dual agency. Broker authorizations and obligations. The buyer authorizes broker and broker agrees to use reasonable skill and diligence to provide guidance to and help buyer with the acquisition of property. Broker will assist buyer by locating and presenting selected properties to buyer, presenting offers authorized by buyer, and assisting buyer in negotiating for acceptance of such offers and, as applicable, terms and conditions following such acceptance, and facilitating the escrow process for such accepted offers. As directed by or agreed with buyer, ordering reports and investigations, and scheduling and attending meetings and appointments with professionals chosen by buyer, and upon request, providing buyer with a list of professionals or vendors who perform the services described in the attached buyer's investigation advisory, provided broker has a referral list for such requested services, and upon request, assisting buyer with the financing process by making referrals to lenders known to the broker and assisting buyer in obtaining a loan pre-qualification. Please get a pre-approval to the extent broker can do so without acting as a mortgage loan broker. See CAR Form BTA for more information. That's another new form. They like to introduce all the new forms in one document. Right? So this is just saying that, hey, here's what we're going to do for you. We're going to help locate properties. We're going to help you negotiate, right? So this is a really important paragraph, a really important section, because this is the bulk of, hey, for the buyer, this is the benefit for being in a buyer representation agreement. Here's all the things we're going to do for you. In fact, I was talking with Claudia today. She's got a buyer looking for country property. And I said, hey, this would be a great opportunity to send out what we call golden letters. Search for properties that meet the buyer's criteria that maybe aren't on the market because there's low inventory right now. Send them out letters and ask if they would consider selling their property, right? Find some off-market listings, find some that have expired, properties that were canceled, right? There's lots of other ways to find properties besides just like the active properties on the MLS, although there's nothing wrong with that as well. We will make sure we set them up on a search either through the MLS or Real Scout or whatever your system is, but make sure they're getting copies of those properties on a daily basis. This is also why I recommend having like your 24-hour market watch set up appropriately so that you're checking that on a daily basis to see if you've got anything that's popping up that matches your buyer's criteria so that you can get to them first before they have a chance to get to you, right? I want to be the hero when it comes to helping them find a property. Okay, so this just says, hey, we're going to help find it, negotiate it, navigate through this whole process. Also, just keep in mind here, it talks about a referral list for third-party vendors. Please put together a list of vendors of who are your pest inspectors, pool inspectors, chimney inspectors, sewer lateral inspectors, home inspectors, right? Anybody that they might need an inspection for, put together a list. And please make sure you have multiple people on that list for each area. It's best to present that list for the buyer and ask them who they would like to use rather than you choosing the inspector yourself, because now it puts it back on the buyer. Like, hey, here's our recommended, or here's our referral partners, whatever, however you want to present that. Please let me know who you would like to use. And then you can always schedule those appointments for them. It tells us that we can do that right here in this paragraph, but it gives them the option to select the service provider themselves. So if they're unhappy with that service provider, it's on them, not you. Okay, same thing with lenders. If B here, 6B, if property contains residential property of 1 to 4 dwelling units, broker will conduct a reasonably competent, diligent visual inspection of the accessible areas of 1 to 4 property, excluding common areas, and disclose to buyer all facts materially affecting the value and desirability of such property that are revealed by this inspection. That would be your AVID, your agent visual inspection disclosure. Buyer shall deliver or communicate to buyer any disclosures, materials, or information received by, in the personal possession of, are personally known to the individual signing for broker during the representation period, unless otherwise specified in writing. Any information provided through broker in the course of representing buyer has not been and will not be verified by broker. Broker services are performed in compliance with federal, state, and local anti-discrimination laws. Okay, we're required to pass along any information we gain about that property to the buyer. Okay, those are our obligations to the buyer. That's a part that I really like to highlight and maybe even like mention to them, like, hey, we can represent you in for sale by owners, expired. We're going to do our due diligence to try to find the best property that matches your criteria, whether it's active on the market right now or not. Okay. In return, the buyer's obligation. The buyer is going to operate in good faith. The buyer agrees to timely view and consider properties selected by broker and negotiate in good faith to acquire property. The buyer further agrees to act in good faith towards the completion of any contract entered into for the property in furtherance of this agreement. B is personal and financial information. Within 5 calendar days from the execution of this agreement, the buyer shall provide relevant personal financial information, including but not limited to proof of funds and a pre-approval pre-qualification letter to broker to assure buyer's ability to acquire property. Buyer fails to provide such information, or if the buyer does not qualify financially to acquire property, then the broker may cancel this agreement in writing. Okay. That just says, hey, we're going to actually like move forward and get pre-approved. Reasonable care and other professional assistance. Buyer is obligated and agrees to read all documents provided to buyer. Buyer agrees to seek desired assistance from the appropriate professionals selected by buyer, such as those referenced in the attached buyer's investigation advisory. The buyer is advised to read the attached buyer's investigation advisory and the buyer transactional advisory for a list of items and other concerns that may warrant investigation by buyer or other professionals. Okay, they're going to exercise reasonable care to do investigation on any properties and seek professional assistance. It also tells them to read all documents. Reports and investigations. Buyer, and I would highlight that when I'm going over this with my buyer, that part of their duty is to review and read all the documents that I send over to them. That they're all important and part of the transaction. They need to take some time to read those documents, right? I'm going to verbally say that to them so that they understand that's part of their obligation, so that when we get to the end of the transaction, they're like, well, I didn't see that on that form. You can be like, well, I told you you're supposed to read them all. I wouldn't, and you didn't ask me to cover it with you, right? I just want to make sure I'm covered. Reports and investigation. Buyer agrees to pay for all reports, investigations, and meetings arranged by broker on buyer's behalf. Buyer material issues. Buyer shall notify broker in writing, CAR form BMI. I bet you guys didn't even know that was a form. It's not a new form. It's been there forever. If any material issues to buyer, such as, but not limited to, buyer requests for information on or concerns regarding any particular subject of interest or importance to buyer. So if something comes up in the inspections, the reports, the seller disclosures, there's actually a form that the buyers can fill out, the BMI form, that goes over any material issues that they have, any questions they want answers to, that you can provide to get those answers. So that's coming straight from the buyer instead of you interpreting the buyer's requests. Okay, keep that in mind. I doubt anybody's ever used that form, and you should. Incorrect, incomplete, or inaccurate information. The buyer agrees to indemnify, defend, and hold broker harmless for all claims, disputes, litigations, judgments, attorney fees, and costs arising from any incorrect information supplied by buyer or from any material issues that buyer fails to disclose in writing to broker. Attorney fees is section 8. In any action, proceeding, or arbitration between buyer and broker arising out of this agreement, buyer, broker are responsible for paying their own attorney fees and costs, except as otherwise specified in paragraph 9A. 9A is dispute resolution. We always have mediation in our contracts. Buyer and broker agree to mediate any dispute or claim arising between them under this agreement before resorting to arbitration or court action. Mediation fees, if any, shall be divided equally among the parties involved. If for any dispute or claim to which this paragraph applies, any party, 1, commences an action without first attempting to resolve the matter through mediation, or 2, before the commencement of an action, refuses to mediate after the request has been made, then that party that if that party is the losing party in any such action, the prevailing party shall be entitled to recover the attorney fees from the non-mediating party, notwithstanding the terms in paragraph 8. Exclusions from the mediation agreement are specified in paragraph 9B. So if somebody decides not to mediate and they go to further action, arbitration, or a lawsuit as part of this agreement, and they end up losing, then they're required to pay all of the fees because they did not mediate first. Mediation terms: the following matters are excluded from mediation: a judicial or non-judicial foreclosure or other action or proceeding to enforce a deed of trust, mortgage, or installment land sale contract as defined in Civil Code 2985, an unlawful detainer action, the filing or enforcement of a mechanic's lien, and any matter that is within the jurisdiction of a probate, small claims, or bankruptcy court. The filing of a court action to enable the recording of a notice of pending action for order of attachment, receivership, injunction, or with other provisional remedies shall not constitute a waiver of the mediation provisions, provided the filing party concurrent with or immediately after such filing makes a request to the court for a stay of litigation pending any mediation proceedings. Okay, you're enjoying this. Arbitration advisory: if a buyer and broker desire to resolve disputes arising between them through arbitration rather than court, they can document their agreement by attaching the signed arbitration agreement, CAR form ARB. That one's actually an existing form as well, that ARB form. So buyer broker agreement is just mediation, it's not arbitration. Keep that in mind unless you include that ARB. Of course, all parties can agree to go from mediation to arbitration. They just aren't required to without that form. Additional advisories. Any questions about that section 9? It was kind of a meaty section. There's a lot in there that hopefully you'll never have to deal with. But any questions?
No, ma'am.
All right. Fabulous. Section 10, advisories, addendum, and disclosures. Same as the purchase agreement. You've got this little section here of additional things that are included as part of this agreement. One of those is the buyer transactional advisory. That's a new form. The buyer's investigation advisory, that's an existing form, and the possible representation of more than one buyer or seller. That was already mentioned above. You could also include the statewide buyer and seller advisory, CAR form SBSA, or any other forms here under section 10. And then section 11 is other terms, because we with our CAR forms enjoy our other terms line. So if you need to spell out anything else in there, you are welcome to. The entire agreement. All understanding between the parties are incorporated into this agreement. Its terms are intended to be by the parties as a final, complete, and exclusive expression of the agreement with respect to its subject matter and may not be contradicted by evidence of any prior agreement or contemporaneous oral agreement. This agreement may not be extended, amended, modified, altered, or changed except in writing and signed by both the buyer and the broker. In the event that any provision of this agreement is held to be ineffective or invalid, the remaining provisions will nevertheless be given full force and effect. The agreement and any supplement, addendum, or modification, including any photocopy, fast mail, or electronic, may be executed in counterparts. That means I might sign one copy, they might sign another copy. As long as the copies are exactly the same, we don't have to sign on the same copy. Okay, that's counterparts. Buyer acknowledges that the buyer has read, understand, and received a copy of and agrees to the terms of this agreement. If it's an entity buyer, like it's an LLC or a trust or something that's actually making the purchase, we would check this box here for entity buyer. We would put the name of who is authorized to sign on behalf of the entity here on the line 3. And then the buyer would be listed as the entity, and the signature would be by the person up here, usually with a title. So if it was like an LLC, it's usually like Amy Petard, president, or if it's a power of attorney, it would be Amy Petard, power of attorney for Carly Goodson. Or if it was a trust, it would be Amy Petard trustee or Amy Petard co-trustee if there was somebody else. So that's how they would sign. But the name of the buyer would be the person or the entity actually making the purchase. Let's see here. Broker signatures are here. You can sign on behalf of the broker. This does not need to get sent to Ed for signatures. You're going to sign on behalf of the broker as the agent representing the broker. The bottom line here, more than one agent from the same firm represents buyer. So if I'm working with this buyer with another agent in our office, we would check this box here. we would put the other agent's name here, you could, or you could just include the additional agent acknowledgement form. It's an AAA form. It's also been an existing form. I don't think there were any changes made to that one. It just outlines who has the ability to represent the buyer in any further transactions. And then if more than one brokerage firm represents the buyer, additional broker acknowledgement is attached. That's the ABA form. So 2 agents from the same brokerage, AAA form, and 2 agents from separate brokerages representing the same buyer would be the ABA form. Again, that's also an existing form. Any questions about that buyer representation and compensation agreement? It's a lot of information. It's really the same as the previous one. They just kind of cleaned it up a little bit and changed it a wee bit. I recommend checking this box here for B2 that you're exclusive. If I was explaining this to my buyers, I'm going to talk about the top, right? The expiration of this offer. I would talk about what properties I would represent them in the purchase of, because that's a good way to outline that you can help them with, new homes as well, and ask them if there's any other counties that they're interested in. It's a great conversation to have there. And I would talk about the compensation. This is a great place to say, hey, basically I work for you for free, because 99% of the time I'm going to get paid by the seller. And in the case that I don't get paid by the seller, we'll have a conversation about that up front. We will always talk about it before you write the offer of what that's going to look like and what the seller is offering for compensation. Okay. I'm probably not going to dig into this middle section very deeply with my buyers. Okay. I would probably let them know that it's an exclusive agreement. If something happens, we have a falling out, I prefer that they come to me first before just canceling this agreement. But if we ever did have a falling out, I would allow them to cancel this agreement and move forward with another agent. So that's kind of how I would summarize that middle section. I would talk about the broker authorizations and obligations, right? I'm going to talk about what my duty to them is and what kind of properties I can represent them in, and that I'm going to provide them with a list of service providers, negotiate on their behalf, and help guide them through this transaction beginning to end. Okay. I'm going to talk about their obligations to me, that they're just going to exercise due diligence and good faith in selecting properties to go see. That they're going to exercise reasonable care, that they're responsible for any reports or inspections that are going to be done on the property, right? So we're just going to have a conversation about that. And then I'm going to remind them that if anytime there's any dispute that arises between me and them due to this agreement, that we would always go to mediation, where we'd work with somebody to come to a amicable agreement on how to move forward. Right?
Amy,
Yes.
So your client signs this, you're actively looking at houses for them, and then all of a sudden they ghost you, they're not returning the phone calls. How do you cancel this if they're not responding to you?
Well, I wouldn't cancel this if they're not responding to me. I would leave it in effect. And then if I ever found out they purchased a property, I'd go after the commission.
Okay.
Or it's a good way to try to get them to respond to you. Chances are, if they're not responding to you, and you haven't heard anything from them, then they're probably not buying a house. They probably had some sort of fear or something happened, and they're embarrassed to tell you that they don't want to move forward, or they can't move forward for whatever reason. So chances are they're not going to buy another house, but this would be a good way to reach out to them, leave them a message, and just be like, hey, Ralph, this is Amy, just checking in with you. I haven't heard from you in a while. I just wanted to make sure, because we have that representation agreement in place. That's good through, the end of June or whatever. I just want to make sure that that's still valid, or if you were looking for us to cancel that, give me a call so that we can discuss it, right? So it would be a good way to have them actually get back in touch with you if they wanted to cancel. Give them that opportunity to reach out and contact you.
Perfect. Thank you so much.
Yep. That way you guys can have a discussion. Okay. So that's kind of how I would go through it with a buyer. I'm just going to go very surface level on it. I'm not going to go like super deep into, I'm not going to read it like I did for you guys. I just did that because it's a new form and I wanted to go through the whole thing and talk it out with you all. So I'm just going to go through it kind of surface level, let them sign and agree to it. There were those forms at the beginning. There's also forms at the end here. We have the new form, the buyer. What time is it? It's 5 o'clock. Are you guys good for like 10 more minutes? 10. All right. Heather's
Yes,
good. So as long as Heather's good, because she's the only one with her screen on, then we're good. It's also being recorded, so if you guys need to bail, you're welcome to, and you can always catch the end of the recording. This buyer transactional advisory is a new form as well, and it's always attached to this buyer representation agreement now. So it's the BTA form. You'll never have to search for it individually because it's always attached. General information. Buying real property is a process that has many different aspects to it. The information below will help you evaluate your role and the roles of others in the buying process. Buyer's obligations, right? We always like to outline the buyer obligations. Reasonable care and other professional assistance. Buyers have an affirmative duty to take steps to protect themselves, including discovery of the legal, practical, and technical implications of discovered or disclosed facts and investigation of information and facts which are known to them or are within their diligent attention and observation. Buyers are obligated to read all documents provided to them. Buyers should seek desired assistance from appropriate professionals selected by them, such as those referenced in the attached buyer's investigation advisory. Buyers are advised to read the attached as those are referenced in the attached buyer's inspection. Oh, wait, hold on. The buyers are advised to read the attached buyer's investigation advisory. I'll get on the right line eventually. For a list of items and other concerns that may warrant investigation by them or other professionals. Communicating important issues. Buyers need to notify their agent in writing of any important or material issues to them. CAR form BMI. You may want to include a copy of that BMI form with this document so that they have a blank copy of it to use it anytime. If buyers' circumstances or interests change during the property buying process, buyers should notify their agent in writing. Agent duties and limitations. Agents perform many services for buyers during the course of the home buying process. The sophistication of the buyers and the experience of others involved in a transaction and the requirements of the specified transaction will all impact the agent's duties. Agent authorizations, obligations, and limitations. For a property transaction of which the agent is aware and not precluded from participating in by buyers during the representation period, agents are authorized to provide and review forms and create a property contract for the acquisition of a specified property, deliver or communicate to buyers any disclosures, materials, or information received by in the personal possession of or personally known to the individual agent signing below. And keep in mind too, that you're required to pass on any information, even if it's the crazy neighbor telling you that information, please pass it on to the buyers. It's a disclosure issue. Even if you think they're psycho, still pass it on. You can covet it with like, you know, hey, the neighbor told me this. She sounds a little crazy. I'm not sure the accuracy. I haven't verified it, but just so you know, this is what the neighbor said, right? It's okay to say that. Put it in writing. If the property contains at least one, but not more than 4 residential units, perform a reasonably competent and diligent visual inspection of the accessible areas of the 1 to 4 units and disclose to buyers any material facts concerning the value or desirability of the property that was observable in the inspection. That's your agent visual inspection disclosure. Unless otherwise specified in writing concerning the value or desirability of the property that was observable during, unless I keep jumping lines this evening, unless otherwise specified in writing, any information provided through agent in the course of representing the buyers has not been and will not be verified by agent, right? Agent services are performed in compliance with federal, state, and local anti-discrimination laws. Agent owes no duty to inspect for common environmental hazards, earthquake weakness, or geological or seismic hazards. Scope of agent's duties. Buyer acknowledges and agree that the agent does not decide what price the buyer should pay or the seller will accept. Just so you know, because this is in here, I probably wouldn't necessarily, or maybe not, include the market conditions advisory anymore with my offer, but I still may include it. But they get this disclosure now. Does not guarantee the condition of the property, does not guarantee the performance, adequacy, or completeness of inspections, services, products, or repairs provided or made by seller or others, does not have an obligation to conduct an inspection of the common areas or areas offsite of the property. In case anybody's wondering what that means, like if you're in an HOA where you have a community park or pool, we're not required to go inspect that park or the pool. We're only inspecting the unit that they're buying. That's what that means by those common areas or offsite places. Unless such defects are visibly observable by the inspection of the reasonable accessible areas of the property or are known to agent. If you're driving through the HOA and there's no water in the pool, please disclose there's no water in the pool, but you don't actually have to like go inspect the pool, okay? So things like that you want to point out, things that are reasonably noticeable as you're going to the property. Shall not be responsible for inspecting public records or permits concerning the title or use of property. It's not our job to go down to the permit department. Please do not go to the permit department on behalf of your buyers. You can go with your buyers, but don't go on their behalf. It's a liability issue. Shall not be responsible for identifying the location of boundary lines, easements, or other encroachments on title. Shall not be responsible for verifying the square footage, representations of others, or information contained in investigation reports, MLS, advertisements, flyers, or other promotional materials. Shall not be responsible for providing legal or tax advice regarding any aspect of the transaction entered into by buyer or seller, and shall not be responsible for providing other advice or information that exceeds the knowledge, education, and experience required to perform real estate license activity. Keep in mind that didn't say that the agent has, it said that required to perform real estate license activity. If you're a previous contractor, throw that out the window, please. Don't comment on and make, statements regarding things that you would have as a contractor versus a real estate agent, but you may want to encourage them to have somebody look at that issue, right? Buyers are advised to and agree to seek legal, tax, insurance, title, and other desired assistance from appropriate professionals. Okay, buyer representation agreement allows dual agency. The representation agreement permits a broker to act as a dual agent for both the buyer and seller in the transaction under California law, even though one individual real estate agent may be the only licensee in direct contact with the buyer on a property transaction, and another individual agent may be the only licensee in direct contact with the seller for that same transaction. Since both agents work with the same firm, the brokerage firm and its agents are all dual agents in the transaction. It is also legally permissible for one real estate agent to be in direct contact with both the buyer and the seller, in which case a dual agency would also be established for both the brokerage firm and the agent in that transaction. If buyer does not want to allow dual agency, then the buyer should discuss with broker the implications of such request and then come to an agreement with the broker. By signing below, buyer agrees they've read, understand, and received a copy of the buyer transactional advisory. Okay. Any questions on that form? Pretty clear, right? Outlines everybody's
ma'am. Good.
obligations, limitations. The last form that's included as part of this long document is the buyer's investigation advisory, which is the same BIA that's always been included with your offers. So it just goes through the importance of property investigation, the broker obligations, and then the different types of inspections or investigations that can be done on a property. It's 2 pages, get signed by the buyer. And that, and then we have the California Consumer Privacy Act Advisory. I lied, there's 2 more forms. We had that buyer investigation advisory at the end, and then the California Consumer Privacy Act Advisory and disclosure notice, just stating that California has a California Consumer Privacy Act advisory, and part of the real estate transaction is public record, the price at which the property sells for. We can't control the photos and what happens to the photos after the close of escrow. So photos of the inside of the property may remain on the internet, and we don't have the ability to control that. So you can read through that and look at that, but that concludes the new buyer representation agreement.
So would you suggest that we have our buyers transition to this one, or wait until the original one they signed runs out and then just have them re-sign this new one?
If they've already signed the original one and they're still under that, you can leave that one in place. You may want to go ahead and have them sign the buyer transactional advisory though, or at least with the next offer that you write, put that BTA at the front of it so that they can review and read that, since it's kind of a new document that's wrapped in. And I think it's a solid document that should be included. But I wouldn't necessarily make them sign a new representation agreement. Okay.
Thank you very much.
We will continue this Tuesday afternoon at 4 o'clock meeting time frame for the next couple of weeks. to get through the rest of these forms. So just so you know, so we have the anticipated broker compensation disclosure. We have the cancellation of buyer representation. There's a new form for that. Notice of identified properties, seller payment to buyer's broker. We don't have to worry about that one. The non-contingent offer advisory, the solar advisory and questionnaire. And then there's a bunch of forms that had some edits, so we'll go over those as well. If you wouldn't forget, please check the chat box and make sure you've logged your attendance if you haven't already. Does anybody have any questions before we wrap up for today?
Hey, Amy, I have a random question, like not random, but how you were reading and I don't know, it was saying like not to be a contractor, you know?
Yes.
You know,
Yes.
so, obviously, you know, like when you're working with like somebody, like I'm working with my mother-in-law, right? So I'm being asked to do things as her daughter-in-law, making calls and doing other things. So how is that okay? Or is that a conflict? Or like, cause I was calling ADT and doing all kinds of stuff to like help her. And I keep like reiterating with her, like, this is not my real estate. This is your daughter-in-law helping you today. Like, you know, like kind of doing that, but I don't
Yeah.
know, you know, I don't want to do anything either. That's going to be, you know what I mean?
Yeah, absolutely. Deborah, right above your comment, you should see the link to log your attendance in the chat box if you scroll up just a little bit. And Heather, I would just make it clear to your mom, and you may even want to like have it in writing that like, here's the things I'm doing because I'm your daughter-in-law, not because this is, as a real estate professional, I would not be doing this for you.
Oh, okay.
Or something, just so she understands, or you keep it clear, but or you just may want to make sure you have that conversation with her.
Yeah, I keep having it with her because she was like asking me to call today another person, and I'm like, I can't do that.
Yeah, but you can always
As a
say
real
no.
estate agent, but as your daughter-in-law, I'm gonna do that for you.
Yeah.
I was like, I'll
Yeah,
help
so
you with
that's
that.
okay.
So I just keep every time I keep telling her, like, this is not me as the worker. This is me as your family member. So I
Yeah,
just keep on saying
right. This is
that.
the problem with working with family. They rely on us heavily for other things as
Yeah,
well. So
yeah.
just make it clear to her that what's
Yeah.
under your real
Yeah.
estate scope and what's not.
Okay, that's what I've
Cool.
been. Okay, cool. Thank you, Amy.
Yeah, thanks everyone for joining us today. I really appreciate everyone hopping on. I hope you guys found this useful and helpful. And we'll just continue working through these new forms over the next couple of weeks, which will take us into Summit.
Okay, so you said like the next 2 weeks, Amy, on Tuesdays?
Probably 2 weeks.
Okay.
Yeah.
Yeah.
4 o'clock on Tuesdays. Cool. Have a fabulous day.
Thank you, Amy. Good night, everybody.